For over 20 years, California has been telling law-abiding gun owners from every other state in America the exact same thing. Your permit means nothing here. Your rights end at our border. Your constitutional protections do not apply in California. It did not matter if you were from Texas. Did not matter if you passed the same FBI background check. Did not matter if you completed certified training. The moment you crossed into California while legally carrying, you were a criminal. On August 19th, a federal judge permanently ended that. Not a temporary restraining order. Not a preliminary injunction that California could work around with 6 pages of new bureaucratic requirements. A permanent injunction that eliminates the discriminatory law entirely. I'm Sarah from GunGuidePro, 10 years in the firearms industry, and this ruling does not just change California. It could reshape how courts across America handle Second Amendment challenges for decades to come. Before we go any further, subscribe to GunGuidePro right now and turn on every single notification. We are a new channel and we are building something genuinely important here. Real-time legal coverage for gun owners who cannot afford to be caught off guard. Every subscriber tells us this content matters and gives us the motivation to keep delivering this level of coverage for you. 2 seconds. Completely free. Hit that subscribe button. Hit that bell. Let's get into exactly what just happened and why it matters far beyond California's borders. To fully understand why this permanent injunction is so significant, you need to understand exactly what California was doing to out-of-state gun owners for over 2 decades. California has 0 reciprocity agreements with any other state. 0, not 1. While 42 states operate under shall-issue permitting systems and 27 states have adopted constitutional carry, California looked at all of that and said none of it matters here. Think about what that meant practically. A business traveler from Texas carrying legally under a valid Texas permit crosses into California. Instantly a felon. A family driving through California on a road trip, forced to disarm at the state line or face criminal charges. A woman visiting relatives in Los Angeles with a valid Florida carry permit, stripped of her right to self-defense the moment she lands. And here is the logical absurdity at the core of California's position. Your home state ran your criminal history, verified your identity, confirmed your training, checked every box. California looked at all of that verified, documented, official information and said we do not trust any of it. Our bureaucracy knows better. FBI data consistently shows that out-of-state permit holders commit violent crimes at rates lower than off-duty law enforcement, lower than off-duty cops. California was not protecting anyone. California was using discriminatory legal architecture to treat law-abiding gun owners from other states as presumptive criminals. Drop your state in the comments right now. Have you ever been stopped from carrying legally because your permit was not recognized in another state? Which state? I personally read and respond to every single comment on this channel. The case is Miller versus California. Earlier in 2026, federal judge Patricia Ramos issued a preliminary ruling declaring California's non-resident carry restriction unconstitutional. That alone was significant. But California being California, they did not accept it. Instead of simply eliminating the discriminatory requirements, which is what the Constitution demanded, California came back to court with a proposal that was somehow even more bureaucratic than the original system. They wanted non-residents to submit multiple sworn affidavits, apply only in specific approved counties, not anywhere in the state, comply with over 6 pages of additional conditions and qualifications. Requirements that California residents themselves never face when applying for the exact same permit. California's legal strategy was transparent. They could not defend the discrimination openly, so they tried to replace it with a different kind of discrimination buried under layers of paperwork and procedure. Same result, different label. Same intentional barrier between law-abiding gun owners and their constitutional rights. The plaintiff's legal team saw through it immediately. They went back to Judge Ramos with one direct argument. Constitutional rights should not require citizens to navigate an administrative maze designed to exhaust and discourage them. The Second Amendment does not become less applicable when you cross state lines. A state cannot create different standards for exercising the same fundamental right based purely on residency. Their demand was simple. Do not fix the process. Eliminate the law. On August 19th, Judge Ramos agreed completely. The permanent injunction she issued was exactly what the plaintiffs demanded. No complicated application process. No county-specific restrictions. No sworn affidavits. No 6 pages of bureaucratic conditions. The law is unconstitutional. It cannot be enforced. Period. Full stop. Which politician in your state do you think is most responsible for building discriminatory carry systems that treat out-of-state permit holders as criminals? Name them in the comments right now. I want to see who this community holds accountable. Here is what makes this ruling genuinely different from most Second Amendment victories, and why it is so much harder for California to simply work around it. Judge Ramos did not issue just a Second Amendment ruling. She applied the Equal Protection Clause of the 14th Amendment under strict scrutiny, the highest legal standard available in American constitutional law. Under strict scrutiny, the government must prove 2 things. First, a compelling government interest. Second, that the policy is the least restrictive means possible of achieving that interest. California failed both tests completely. On compelling interest, FBI data shows out-of-state permit holders commit violent crimes at lower rates than off-duty law enforcement. There is no public safety justification. On least restrictive means that 6-page county-specific sworn affidavit application system was the precise opposite of least restrictive. It was deliberately designed to maximize burden and minimize compliance. And here is the critical practical difference with a permanent injunction versus a panel ruling. California officials, including Attorney General Rob Bonta, are now under a direct federal court order. Violating that order is not just legally problematic. It is contempt of federal court. The legal force behind this ruling is significantly stronger than a typical appellate decision. California has to either appeal this ruling, which means it goes to the Ninth Circuit, or accept that this law is gone. What is your favorite Second Amendment ruling of the last decade? Heller, McDonald, Bruin, or this Miller versus California permanent injunction? Drop it in the comments. I genuinely want to know what this community considers the most important legal victory we have seen. Here is the part of this story that most coverage is completely missing, because the implications of Miller versus California go far beyond California's 39 million residents. The equal protection framework that won this case applies with identical force to carry restrictions in every other restrictive state in America. New York does not recognize out-of-state permits. Under this framework, equal protection violation. Hawaii treats non-residents differently for the exact same constitutional right, strict scrutiny, failure. New Jersey effectively bans all non-resident carry, unconstitutional under this reasoning. Connecticut, Maryland, Massachusetts, Illinois. All of them operate versions of the same discriminatory system that California just had permanently enjoined. Within 72 hours of the ruling, 3 new federal lawsuits were filed. One in New York, one in Hawaii, one in New Jersey. All 3 cite Miller versus California directly. The legal blueprint is already deployed and moving through the courts right now. This ruling also represents something courts have increasingly been doing in Second Amendment cases, refusing to allow states to substitute one unconstitutional system with another. That refusal, the insistence on elimination rather than modification, is exactly the approach gun rights advocates have demanded for years. It creates durable legal progress rather than temporary wins that states immediately work around. California's Attorney General will almost certainly appeal to the Ninth Circuit. That is what California does every single time they lose a significant Second Amendment case. But here is the critical difference with a permanent injunction. Unlike a three-judge panel ruling, a permanent injunction carries immediate legal force. California officials are under a direct court order right now. Seeking a stay while the appeal proceeds is possible, but courts grant stays based on the likelihood that the appealing party will ultimately succeed. Given the strength of the equal protection argument, and given that California already failed to justify its discrimination under strict scrutiny, obtaining a stay is not certain. It is not even likely. If the Ninth Circuit denies the stay, the injunction holds during the entire appeals process. Out-of-state permit holders can carry legally in California while the legal battle continues. That is an enormous practical win regardless of what ultimately happens at the appellate level. And if this reaches the Supreme Court, the current 6-3 conservative majority has consistently ruled in favor of Second Amendment protections. The equal protection argument on top of the Second Amendment foundation gives this case two independent constitutional legs. That is a very strong position before this court. What is your prediction? Will the Ninth Circuit grant a stay while California appeals, or will the injunction hold during the entire appeals process? Type stay granted or injunction holds in the comments. I want honest predictions, not wishful thinking. Here is your practical guidance, because knowing about a ruling only matters if you understand how to act on it. If you are a gun owner who travels to California, monitor this case extremely closely over the next 60 to 90 days. The injunction is in effect right now. But if California successfully obtains a stay pending appeal, enforcement could resume. Do not make permanent decisions about carrying in California based on the current ruling without checking for updates. This is exactly why subscribing to GunGuidePro and turning on notifications matters. When the stay decision comes down, you will know within minutes. If you live in New York, Hawaii, New Jersey, Massachusetts, or any other state that discriminates against out-of-state permit holders, the lawsuits filed in your circuit using Miller versus California as precedent are the cases to watch right now. Firearms Policy Coalition, Second Amendment Foundation, and Gun Owners of America are all actively litigating these challenges. Support them financially if you can. Their legal work directly funds the cases protecting your rights. If you are a gun owner in a constitutional carry state, do not tune out. A Supreme Court ruling establishing nationwide carry reciprocity raises constitutional protection for every gun owner in every state. What happens in California's courts eventually affects your rights too. Here is the absolute bottom line. For over 20 years, California told law-abiding gun owners from other states that their constitutional rights ended at the state line. They built a discriminatory two-tier system designed to exhaust and discourage non-residents from exercising their Second Amendment rights. And when a court told them to fix it, they tried to replace it with something equally unconstitutional, buried under 6 pages of bureaucratic requirements. On August 19th, federal judge Patricia Ramos said enough. The law is gone. Permanently enjoined. 0 workarounds permitted. And the equal protection framework that won this case is already being deployed against similar laws in New York, Hawaii, and New Jersey. The Second Amendment does not have a residency requirement. Courts are finally starting to enforce that truth. Here is what you do right now. First, subscribe to GunGuidePro and hit that notification bell immediately. We are a new channel, and every single subscriber gives us the motivation and resources to keep covering these developments at this level. The Ninth Circuit appeal is coming, and when it drops, Firearms Advisor covers it the second it happens. Second, smash that like button and share this video with every gun owner you know who travels or has ever been told their carry permit means nothing at a state line. Third, answer all 3 questions in the comments right now. What state are you watching from? Which politician do you hold most responsible for discriminatory carry restrictions? And what is your favorite Second Amendment ruling of your lifetime? I personally read and respond to every single comment on this channel. Gun Guide Pro is just getting started. The legal battles coming over the next 12 months are going to be historic. Be here for every single one of them. Stay informed, stay armed, stay free. I'm Sarah from Gun Guide Pro. See you in the next one when California files their appeal.